Kululeko, can you just indicate if we do have any apologies?
Yes, good morning, Mr. Mkiva, and good morning to members. Yes, Chair, we have 3 apologies from Mr. Raita, Ms. Nita, and Mr. Karim.
Yes. And I don't know if you can flight the agenda from where you are, or you can just pronounce on it.
Okay, I'll flight it now, Mr. Mkiva.
Honorable members, the agenda is as outlined on the platform. The item number 1 is about the public hearing on the Financial Matters Amendment Bill. And then we will have the responses by the Treasury. So as it has been indicated that we only had a single submission from the Congress of the South African Trade Unions. And I think without further ado, I would like now to invite COSATU, as led by Mr. Matthew Parks, to make the presentation.
Okay, we can start, Chair. Good morning, Chair. Good morning to honorable members. Thank you for giving us space as COSATU just to make our views. It's slightly embarrassing that we're the only organization making a submission, but nonetheless, Chair, we do think it is an important bill that does have an important impact upon workers, and hence our interest in it. I think, Chair, it'd also be correct for us as COSATU, I think, just to express our sorrow and our sadness at the tragic passing away of Comrade Tina Jumat Peterson last night. Tina was a former SART member in a previous life before 1994, but we also felt that she had played a role as a member of parliament in many different caps over many years, including the legislature in the Northern Cape. So I think, it is quite a sad loss to lose such a good public servant, and also someone who was so young as well. So just to express our condolences to those who had worked closely with her and so forth. But I think, it's a tragic loss, Comrade Chair. But Chair, I think just on the bill, the Financial Matters Amendment Bill, I think to appreciate, the committee giving us a chance to raise some of our thoughts on the bill. Overall, Chair, as COSATU, we support the FMA bill. I think it's building upon previous financial matters and other amendment bills that colleagues in Treasury have submitted over the years. I think, obviously the ones which deal with the issue of partners, we support it. We think it's an important bill that, from our viewpoint, will help to address challenges that some military personnel, military veterans partners have experienced when accessing pension benefits when their partners or the ex-partners pass away or during separations. Which I will also welcome the provisions providing for the extension of existing legal requirements to the associated institutions' pension funds, and thus providing the same rights and protections for those fund members rather. Chair, I think we also do welcome the provisions that seek to address some of the problems that society we've all experienced and seen in the auditing profession. I've seen recently where some auditors helped cover up corruption in the firms, and the SOEs are meant to play an auditing and oversight role, and sometimes they even were implicated in them as well. So, Chair, just with regards to the amendments to the Military Pensions Act, so we support the amendments to the Military Pension Act. Our vantage points that they're going to provide for recognition and the inclusion of military personnel life partners. We think this is critical to protecting the rights and the needs of those military veterans, their partners, their families, their dependents. And we also believe these are amendments which are in line with the non-sexist values of the Constitution, the Bill of Rights, and the need to prevent discrimination based upon gender or sexual orientation. Chair, I think also critically, these amendments will help protect the rights of the partners and the ex-partners and dependents and the children of the deceased military personnel, who often struggle to access the remaining pension benefits due to the loss of a loved one. And we know that, when people pass away, often it can be quite a complicated process. And we need to kind of remove these kind of legal obstacles when these families are experiencing financial losses, emotional losses, and so forth. So we support the FMA bill amendments to the Military Pension Act in full. We welcome them. Similarly, Chair, in terms of the amendments to to extend coverage to associated institution pension funds, we want to welcome these, and that they're basically, in essence, extending the existing legal framework to these pension funds. Again, we think this is important for workers, for pensioners of such funds, as well as their partners and their dependents, who otherwise don't always enjoy the same legal framework and rights, and also critically, the regulatory oversight as well. So I think, again, we want to welcome the provisions providing for the extension of the clean break principles during divorces and separations of assets. And again, Chair, it might seem we take it for granted, but often this doesn't always happen, and hence this amendment is necessary. And we think, Chair, this is especially important for women and children in abusive relationships or financially dependent upon relationships. So the sooner they're able to separate the assets, the faster they can go to move on with their lives, source alternative accommodation, and so forth. And I think members of Parliament would be quite familiar with the difficulties, for example, that members of the Transnet Pension Fund or the former Bophuthatswana Public Service Pension Fund had gone through previously, with little recourse or protection. So this, we think, is exactly why this legal amendment is necessary and is long overdue, and thus we must support it. Then, Chair, just get into the last kind of areas of amendments. So, we support the amendments to the Auditing Profession Act. We think they're a correct response to many of the issues highlighted in the Zondo Commission, which exposed collusion between some auditors and the companies and the SOCs that were paid and obligated to audit. And so we do welcome the proposed amendments to the Auditing Profession Act. And they do build upon the previous amendments to the previous FMA Act and the Auditing Profession Act about 2 years ago. But we do remain concerned as COSATU Chair by what we think is often an unhealthy relationship between some auditors and the institutions they are hired to audit. We have witnessed at times a very cozy relationship between some auditors and their clients, and with some of these auditing contracts being in place for decades. I think URBA had even made examples of some auditing contracts going for 80 years, etc. I think we're familiar with the King reports, and they highlighted this as a key cause of, and at times, an incestuous relationship. We've seen, Chair, unfortunately, in the public and the private sector, some auditors turning a blind eye or even being complicit in illegal activities to protect long-standing contracts, and often these contracts are quite lucrative. And I think, Chair, the King report, we believe, recommends time limits to such auditing contracts. And again, the principle of term limits is one which also finds value or expression in the Constitution. For example, the President or the Premier are limited to two terms, 10 years combined. The similar term limits, if you look at some of the boards in the public and the private sector. Chair, so URBA, the Independent Regulatory Board of Auditors, correctly and progressively instituted a rule requiring the mandatory rotation of auditing firms, the MAFA rule, after 10 years. We thought that's a very progressive and bold stance by URBA in 2017. This required the rotation of auditors every decade to try to prevent an incestuous, financially dependent upon relationship between the auditors and the companies that are auditing. But Chair, we've raised this COSATU with the previous FMA bill in 2018, 2019, even with the Auditing Profession Act in 2020, 2021, the need to elevate this rotation rule from simply being an in-house rule set by URBA, which could easily be revoked, to one that's kind of elevated and protected and entrenched in law. Unfortunately, during those two times, we had received positive responses from the NCP colleagues, members, rather. We don't think the NA took it seriously enough, and often we were told by Treasury Times, well, they'll look at this in an alternative another time. And our fear, Chair, that time was that you could have a change of leadership at URBA. They could be lobbied or whatever, and that rule could simply be deleted. And of course, there is a vested financial interest by compromise auditors to want to get away or to end such a progressive rule. We felt, Chair, that even the 10 years itself was a bit too broad. It should have been reduced to 5 years, but at least 10 years was a step in the right direction. It did provide for some measures of protection, etc. So I think, Chair, members, why we're raising it is because we saw last week on the 31st of May, the Supreme Court of Appeal made a ruling that IRBA doesn't have, under the Auditing Profession Act, the legislative power to institute the mandatory auditing firm rotation rule. So that's now been scrapped. We're not sure if IRBA will try to appeal that, but that would mean they'd have to go to the Constitutional Court, etc. But when you look at the judgment of the Supreme Court, they're just simply saying that in the Auditing Profession Act, that power hasn't been given to IRBA. So not saying that the rule is unconstitutional per se, they're just simply saying that, well, if you want to have that power, you need to then provide for that power to be delegated or provided to IRBA in the Auditing Act. Comrade Chair?
Comrade Matthew, you are breaking.
Chair, I think it's you, not Mr. Fox.
I think it's your network. Comrade Matthew is audible. Maybe from your side. Can you continue, Comrade Matthew?
Okay. No, Commissioner, thanks, Comrade Mahlangu, Honourable Chairperson Mahlangu. Yeah, so Chair, so we've raised it because of what's happened recently in the last week. We think this is really an opportune time for the members to look at it. We understand members will say, well, look, this would be a new provision in the bill, and that would be correct. And we're, in our understanding of the parliamentary rules, that will require getting a resolution from the House to give a mandate to the Select Committee to make such an additional provision. We don't think that would be too difficult to do. We think it would enhance the existing provision, and it wouldn't be a new issue because we've been discussing this at Parliament in the NA, the NCOP since 2018. And obviously, there is a recent context of the Supreme Court ruling now as well. We don't think it would be a complicated thing too as well, Chair, because it would simply be inserting an additional provision, not a complicated one, but just simply one to empower IRBA to institute such a rule. We don't think it should take too long. One could say we would be very sensitive to the argument that, well, we're coming towards the end of the sixth Parliament. Parliament will be rising in November, etc. There's not huge amounts of time. There's a recess shortly as well. But we think that we're now in the beginning of June. We would have space to, with the NCOP, to make some additional provision referring back to the NA for concurrence. We would think we would still have time to do it, but we think it'd be well worthwhile to do so. The alternative is simply, Chair, not doing it and saying, well, Treasury can look at it later on. Look, that can be a plan B, but that does mean a 2-year interregnum. And we're not sure what happens after elections, a new administration, will it be kicked down the road further, et cetera, et cetera. So basically, Chair, one proposal to this bill for the consideration of the Select Committee, so not the Standing Committee, apologies, is to insert a new section in the bill formalizing a law what was then the existing IRBA rule, providing for the mandatory rotation of auditing firms. We wanted to suggest that we even consider reducing the 10-year period to 5 years. But I think, Chair, the main thing would be simply to elevate the existing rule, which has now been scrapped, into the bill. So therefore, the IRBA would be fully empowered to reinstitute such a progressive rule going forward. So, Chair, in conclusion, we support the amendments to the Military Pension Act. They are progressive. They're needed to help current and former Defence Force members, their families, their partners in the moments of need. We similarly support the extension of the legal framework to associated institution pension funds, thus providing protection, in particular for the clean break principles for those pension fund members and again their families, especially for women and the children. We do welcome the proposed amendments to the Auditing Profession Act. But we really do feel that this is really the opportune time to further strengthen it with regards to the mandatory auditing rotation rule. We hope the members of Parliament would take into account our submission and we think really now is the best time to do so, Chair. I think that's our presentation in a nutshell, Chair. It's short and sweet. I think like the bill is also short and to the point, but thanks very much to members, Chair. Thanks very much.
No, thank you very much, Comrade Matthew Parks. I think it is quite very concise and precise and to the point, and that is actually quite very helpful because it is going to allow the Treasury, as we interact with your presentation, to also provide, quite very focused responses on the areas that you require, their intervention. I think at this point, then, honorable members, having had a full appreciation of the presentation by COSATU, I think we must then invite the National Treasury to provide responses, and then we will then take it from there. Who is leading the delegation of National Treasury in this respect?
Good morning, Chairperson. It's MP van Schoor, Chief Director Legislation from National Treasury, but I'm also joined by other colleagues from Treasury and also the CEO of IRBA and other IRBA representatives are in the meeting. May I proceed?
Okay, maybe as the starting point, if you just very quickly, if you can just introduce those that are with you, and then from there on, you can then provide your responses as requested.
In the meeting is Dr. Duncan Peterson, the DDG of Asset and Liability Management of Treasury. Then a colleague from my unit, Nkaniso Sekobi. So I'm just checking who else is in the meeting, Chairperson. Yeah, I don't see anyone else. And then from the IRBA, the CEO Imre Nagy is in the meeting. And yeah, in Gillian Bailey also from the IRBA. I hope I haven't missed anyone. May I proceed, Chairperson? Chairperson?
Yes, you may proceed now. Thank you very much.
Yes, in response to COSATU's submission, we obviously appreciate the support for the amendments in the bill to the Military Pensions Act and also the Associated Institutions Pension Fund Act, dealing with the amalgamation of that fund into the GPF, which will also then mean that the clean break principle applies. Now, these two amendments there were individuals that are affected by these amendments that brought this to our attention, and also GPA requested that we made this amendment. These amendments, on the COSATU submission in relation to the auditing profession, there's one amendment that they supported, and then the new amendment that they proposing in respect of the mandatory rotation rule. In the Standing Committee of Finance, the response of Treasury was that it will be included when we do a thorough review of the Audit Profession Act, and that will only be then tabled in Parliament after the 2014 elections. But as COSATU pointed out, there is this Supreme Court of Appeal judgment that ruled the rule that the IRBA issued as not legal, that they don't have the authority to do. So we acknowledge that there is some urgency to provide for that in the Auditing Profession Act as soon as possible. The challenge that we have is that there are amendments in the bill that's currently before the committee that's urgent, in particular the Land Bank amendment, and also the amendments in relation to the Two Pensions Act. The affected individuals have been waiting for a while for these amendments. So what we would like to, for the committee to consider that the amendment not be included now, because it will result in the NCOP having public hearings on the amendment since new, and also that it must be referred back to the NA for consideration, and they similarly will have to have public hearings, meaning that the bill, if then approved by the NCOP and then later the NA, will be passed much later in the year. That Treasury look at an alternative ways of bringing this amendment, the rotation rule, the mandatory rotation rule, as soon as possible. Chair, but I just want to, if with your permission, if I can invite the CEO of Herbal, if he wants to add anything, and then also my colleague, Dr. Peterson, in relation to the Land Bank amendment. Thank you.
No, certainly you can. We would like to have an overall response on all the matters which are raised by COSATU. So by all means, you can line up your colleagues as you may wish to do. Thank you.
Okay, Imre, do you want to come in?
Thank you, MP. Good morning, Honourable Chair and Honourable members. Thank you for the opportunity. Chair, Honourable Chair, Honourable Member Parks of COSATU did capture the impact and the outcome of the recent judgment correctly. The judgment set aside the mandatory firm rotation rule based on the fact that the IRBA did not have the power to sort of put such a rule in place. Therefore, it was declared ultra virus. But it did not address address the issue around whether MAFR is of value or actually needed. The merit of MAFR was not under question. We still, as the IRBA, believe that there is benefit to firm rotation, and we will continue to support firm rotation and the legislation of the rule. I'd like to mention that as of last week, about 91% of JSE listed entities had already rotated. So there's not an immediate risk, but we have identified quite a number of entities that still needed to rotate, some with audit firm tenures between 25 and 118 years. But Chair, yes, we are happy to support National Treasury to fast track the possible legislation where possible of this rule to address the gap if there's nothing urgent in this bill. But yes, happy to consult also and assist by consulting our own senior counsel on how the rule could be best incorporated into our act. But Chair, I think that would be our response in addition to what COSATU has already raised, which we agree with. But yes, from a timing perspective, if it's not possible now, I did indicate to Treasury that we're ready to support Treasury on any alternative way to get the rule legislated as quickly as possible, because the fact is we do have a gap now in that the rule was set aside. And it is unlikely at this stage that we'll appeal the ruling just because of cost, and taking it to the Constitutional Court will again take a lot of time and effort and cost. We think that the best way to address the issue is to legislate the rule. Thank you, Honourable Chair.
Good morning, Chair and honourable members. Duncan Peterson here. I hope you can hear me. I am the DDG at the Treasury responsible for asset and liability management. As per the conversation, MP has just asked me to come in on the urgency of the land bank matter. As the honourable members will know, as part of the Financial Matters Amendment Bill that's being proposed, there are certain proposals being made to align the Land Bank Act to the Companies Act. Part of the reason these proposals are important, honourable members, is because, as you know, for the last over 2 years, in fact, the Land Bank has been in a state of technical default, and it has been negotiating various liability solutions with its lenders. We've gone through, at this stage, about 4 different liability solutions, none of which have been accepted or agreed upon between the lenders and the Land Bank. And what has happened in the meantime is that the Land Bank has slowly consolidated its book, paid off debt, and it hasn't really been able to fulfill effectively its developmental mandate or its mandate in terms of the support that it gives to the agricultural sector. Our view is that the particular amendment that's being proposed here is going to be very critical to help us to close out the current liability solution. And I think because what it does is it gives us another lever to be able to negotiate with the banks to bring all the Land Bank lenders to the table and to get them to agree on the liability solution. So from our point of view, as a result of that, and as a result of the length of time that's expired for this, for the Land Bank being in the state that it's in, the sooner we can get that particular amendment passed, the better. Because what it will allow us to do is it will allow us to more quickly close the liability solution and restore the Land Bank back to its previous role in terms of its support to the agricultural sector and its broader developmental mandate. So I just thought I'd make those points, honourable members, just to illustrate the link between this particular amendment and the ability of it to allow us to close out the liability solution and for the Land Bank to be able to start functioning properly again. And happy to take any questions on this matter. Thank you.
Would that be the completion of the response from the Treasury?
Yes, Chairperson, thank you.
Thank you very much. Thank you very much, officials of the National Treasury. I just want to say now, members, those are the responses that we have, having had the full appreciation of the presentation from COSATU. I just want to check if the members would like to ask questions of clarity or make comments on both the presentation of COSATU as well as the responses provided by the National Treasury. I see the hand of Honorable Muletsane, as well as the hand of Honorable Oukamp. Are there any other members? If there are no other members, then I will give the opportunity to Honorable Muletsane. Honorable Muletsane, you will come first, and then Honorable Oukamp will follow.
Thank you, Chairperson. Let me acknowledge the presentation and good morning to everyone. I just want to check, Chairperson, with the Treasury, whether all the military veterans are receiving pensions, especially those who are from Umkhonto weSizwe, as they were promised by the government. Secondly, usually when I engage with them, they always talk about, they say there's a military pension, there's a special military pension. I just need a clarity from the Treasury to explain to me what is the difference between those two pensions and who are those who qualify for special pension. Thank you, Chairperson.
Thank you, Honorable Muletsane. Can we have Honorable Oukamp?
Good morning, Chairperson. Thank you for the opportunity. I'm going to be very brief. Honorable Chairperson, with regards to the term limits of auditing profession people, it is very important to note that obviously the rule was made by IRBA and then was set aside by the courts. I think we need to really delve into this. COSATU makes the proposal that term limits of 5 years instead of 10 are being applied. I think that we need to get the inputs of various role players in the auditing profession. 5 years can be seen by a lot of people as a very short term. We must remember that auditors also must get to a point where they really truly understand the business model of each of their clients. It's not only a matter of going in and auditing it. You must understand the business model in order to see whether there are any loopholes that any client are trying to take, and in order for you then to audit on that. So I think it is very important that we do not haste with this and that we get the public inputs of the auditing profession, and not only IRBA, but the auditing profession as a whole, and get their opinions on this so that we don't burn our fingers with any legislation going forward. With regards to the Military Pension Fund and Land Bank, I will reserve my rights to speak on that later on. Thank you, Chairperson.
Thank you, Honorable Okamp. I don't see any other hand from the members. Let's give the opportunity to the Treasury officials to respond on those matters.
Chairperson, there's firstly the questions from Honorable Moletswane. There are different laws regulating military pensions, military veterans, and also the Special Pensions Act. I would not be in a position to give him exposition of the difference between the benefits under these 3 acts. What we'll do, we'll compile a document explaining these the benefits available and who qualifies for those benefits, and submit it to the committee as soon as possible. Yeah, in respect of Honorable Okamp, I think that the point is, if there's an amendment proposed now, it will be a new one, and then Parliament, in terms of its own procedures, will have to have public consultation on such an amendment. But as I indicate, our preference would be if the committee accepts so that we process this amendment through a different bill, and but that we do understand the urgency of getting it to be law as soon as possible. Thank you.
That's the response, honorable members. I don't know if is there any follow-up question or that suffices. Perhaps if the members are fine with that, I just want to check with Comrade Matthew Parks if maybe you may want to ask further questions from the Treasury in relation to their response to your presentation. I would certainly want to offer you that opportunity. I don't want to take it for granted that you are pretty covered by that response. You may have an opportunity to further maybe give a further deliberation and further advice on how you would want certain matters to be handled. Thank you.
Okay, no, thanks very much, Chair, and to honourable members and to the colleagues from Treasury. So just 2 sets of thought. I think just to Honourable Moletsane's question on the issue of military veterans from MK and so forth, I think there are challenges. I think the Department of Military Veterans have been trying to clean it up, but from what I understand from that department, there are huge problems with regards to military veterans for former members from MK and so forth. I don't think it's been so much problem with the law, but I think it's been more a problem of the issue of administration, implementation, and so forth. Chair, just in terms of we welcome Honourable Okamp's call that having a further special discussion or hearing, etc., on the mandatory auditing firm rotation rule, and so I think there is an argument for a 10-year period and so forth. Or one could argue that a 10-year term is in line with the constitutional precedents for the presidency, premiers, boards, etc., etc. So that you could make an argument for it, and we would be happy just to have the 10-year rule being reinstated. Chair, I think our concern is that we had a discussion in the 5th Parliament when the FMA bill came in 2018, and there was amendments to the Auditing Profession Act at that time. And the response by Treasury at that time was that we'll come with a bill after the 2019 elections. Then in 2020, a new Auditing Profession bill came to Parliament, and there was no provision for it. There was absolute silence, and the response of Treasury colleagues that, well, we forgot about it, but we'll bring it back in a future bill. So basically, Chair, without being pedantic, I want to appreciate colleagues in Treasury that are dealing with many different bills, etc. Not just one bill, but we've been having this discussion for 5 years. And so one understands that we must get this bill done urgently. There's implications and so forth. But to say that we'll come with a bill after elections, that might sound like a short space of time, a year. But our experience, Chair, without being pedantic again, is that it takes on average about 5 years for legislation to move from any department to Pretoria, through all the internal processing of cabinet and DG cluster, etc., public comment, chief state law advisor to the House of the Parliament, etc. It's a 5-year plus journey. I think that's the concern. I mean, this bill itself, Chair, many other bills you would have seen would have been in the National Assembly a year ago, 2 years ago, etc. So it is a bit concerning, Chair, that we have a very significant court ruling last week, and then our response is not to say let's fix it now, but to say okay, we'll come back in a year's time, etc., etc. So that's the concern, Chair, and the experience doesn't give one confidence in that regard, and it wouldn't be a complex provision to insert. So there is some space left, not too much time, but the fact that the bill is now in the NCOP, there is a small window of period. So ideally, we would still ask Treasury members of Parliament to just consider lifting the existing or the now repealed or revoked MAFA rule into the Act now. But if not, at least then a firm commitment, etc., that we start drafting the bill at least now at Treasury, so that when the 7th Parliament is sworn in 11 months, 12 months time, that bill can be immediately tabled before Parliament. It's a progressive bill, Chair, and we think it will make a significant difference towards cleaning up the state, society, etc. But again, also, Chair, we shouldn't feel this is simply an exception in an otherwise very smooth sailing ocean. We were grey listed, I think, was it December last year, and partly the reason being is that the international community just simply believes that when it comes to the issues of corruption, of cleaning up the state, etc., that we're very good at talk as a country, but when it comes to practical actions, often we're found to be a little bit wanting. So I think, Chair, this for us would be a missed opportunity if we don't amend it now. But at least if we're not going to amend it now, at least if Treasury colleagues can begin their actual work now. So to come April or May next year, that bill has already been approved and is simply ready for tabling at Parliament, etc. But yeah, thanks very much, Chair, and to honourable members for giving us space. Thank you, Chair.
No, thank you, Honourable Matthew Parks. You've been in the President of Parliament for so many decades, and I think we can bestow you that prefix. I just want to get an understanding, maybe from the Treasury, in terms of the time frame, given the fact that you pointing to the urgency of the bill being processed as soon as possible, because it is amongst the priority of matters that ought to be brought forward. From a time frame perspective, I just want to check what would it take for them to put up all the necessary documentation in ensuring that that dossier comes before Parliament, at her earliest convenience. The time frame issue that you are raising, I think it is very important. And also, having said that, that's the only thing that I will say, because I think it's quite very succinct in terms of what you have put forward in your presentation. And I'm covered also by some of the questions which were raised by the members. Treasury, that's the additional intervention from COSATU. If maybe then you can deal with that and maybe make a summation as well, so that we can then proceed to the other items. I give you the second bite, National Treasury.
Thank you, Honourable Chair. Yes, I hope I understand your question correctly. Is that do you want to give an indication as to when we will bring back such an amendment, or are you talking about what if this amendment is included in the bill now? So I just want to confirm in respect how I should respond.
No, I'm not talking about new amendments because that becomes a total new process altogether. Yes.
Okay, okay, I understand. And obviously, we can't speak for how long Parliament will take. But our estimate is that if this amendment is now proposed by the NCOP, it will have to get permission, and then it will have to have public hearings on the proposed amendment. And then once it's adopted by the NCOP, it will be referred to the NA, and then the Standing Committee of Finance should also have to have public hearings. So it seems that in that instance, the bill is only likely to be passed by Parliament, given that it's going into recess quite soon, around October, and then it must still be assented to by the President. And given the urgent amendment, in particular the one in relation to the land bank, we're requesting that's the reason why we're requesting that amendment not be included now. I just want to indicate, and obviously we need approval from our principals, but there's alternative ways of bringing this amendment not through an entirely new process that that might be possible to bring it sooner than only tabling a bill after the 2024 elections. But that we need to explore, and we can give a response to the committee in the next week or so to indicate whether that is a feasible alternative to including the the amendment in this bill, or postponing it till a new process after the 2024 elections. Thank you, Chair.
No. If I'm not sure whether we are understanding each other here. If you are suggesting that the amendment to the land bank bill must not be brought now, when are you suggesting that it should be brought?
No, Chairperson, the amendment in the land bank amendment is the urgent amendment that we would like to go through as soon as possible. The amendment to the Ordering Profession Act is the one that COSATU is proposing, which would be a new amendment to be included in this bill, and for that we need to follow the process. Or Parliament has to follow the process in terms of getting permission for the amendment, having public hearings, and the bill going back to the NA. And that would result in all the amendments in the current bill only be passed into law later. I hope that's clear.
No, that's clear. I'm not sure if I had interrupted you. Were you finished with your response?
No, Chair, I think I was finished. The only thing is that we are considering other options of bringing the bill or the amendment to the Ordering Profession Act sooner than only tabling a bill after the elections. But I can't at this point confirm whether that's going to be feasible or not. But if the committee, then we can respond at the next, I don't know if they're still going to meet next week, maybe at the meeting next week, to indicate whether that option is possible. Thank you.
Okay, no, thank you very much. I think we must say that what COSATU is placing before us is quite very, very important for all of these matters to be prioritized. And on the side of Parliament, obviously, we must try to do everything that we can to expedite these matters, because they relate as well to service delivery. They relate to the transformation that is required. They relate to the growth of the economy and the inclusivity of that economy at the same time. Having said that, I wish to appreciate your responses from Treasury, and I really hope that this is not just an exercise to tick the boxes. It is really intended to ensure that what COSATU is raising on behalf of the public, because they represent of course, the labor, both those that are employed, and they also represent those that are unemployed. And therefore, they represent quite a very big section of our society. And the issues that they raise, therefore, they resonate with our people on the ground. And we want these matters, therefore, to really be taken into account when we consider some of these interventions that are required insofar as the required amendments. So having said that, Mr. Matthew Marks, we want to express our appreciation for always having your eye on the issues that are happening in the landscape of the national question in our country, especially issues that relate to bread and butter matters, as well as developmental issues and transformational issues that should be prioritized. We express our appreciation. To us, it doesn't matter that it is only you that came today, but it shows your commitment to the cause, that in spite of the fact that there was an expectation that sections of society raised some of the matters in relation to the subject at hand, but you are always standing ready to raise a hand and provide, meaningful contribution that requires our attention. And therefore, Comrade Matthew, we really appreciate your steadfastness and your forthrightness. Thank you so much. And equally, let me express on behalf of the Select Committee on Finance appreciation to the officials of the National Treasury for having come through. And I want to say you do have a takeaway from this meeting, and it's very important, therefore, that you do something with that takeaway. And we want to say thank you so much. We can now release you. Our meeting will proceed because we have other items. Thank you so much.
Thank you, Chairperson.
Comrade Matthew Parks, you would want to make your parting shot?
He has exited the platform, Chair, already.
In respect of item number 2, which relates to the minutes, I am not sure, given the instability of the net and the fact that the chairperson of this meeting is not here. I want to get a confirmation from the Secretariat insofar as the quorum, if we are in a position to handle issues that are related to the minutes.
Yes, Chair. We do have quorum, Chairperson. We have 6 members in the platform. On the issue of the net that you raised, Chair, we still have another meeting, which is our last meeting next week. So if the committee feels that we can adopt these minutes next week, we are fine with that, Chairperson. We can even adopt them today, Chair.
Members, what is your feeling in relation to us? I had thought that we're going to limit this meeting really to this briefing.
Chair, can I come in?
Yes, Honorable Mahlangu.
I am of the opinion, Chairperson, that we don't delay the meetings and pack them. Let's deal with them because the briefing was really short.
Okay.
If we can, we are making a quorum. Let's deal with the minutes. Thank you.
Chairperson,
Okay.
I also support that. We are here, we have a quorum, and to go through the minutes quickly, we've got time to do it. I think we can do it now. Thank you.
All right. No, that's wonderful. I believe in consulting. It's one of the basic tenets of democracy. That, but now I think I'm getting a clear direction that that's what we should do. So let's look at the.
There's a difference between consulting and listening. Maybe you should listen more, colleague.
Well, consulting and listening are also both part of the tenets of democracy. We don't have to separate them. Let's look at the set of the minutes of the 18th of April. These minutes were obviously shared with the members. And it's just a question of ensuring that quality assurance by way of looking at some things that might have been overlooked or mistakes that are grammatical or things that have been omitted. Yeah, roll down. As he rolls down, members, you may indicate if there is anything that you see that is not included, or those are the minutes of the 18th, members. Do we have any mover for the adoption of these minutes as a true reflection?
I move Chairperson Mahlangu.
Honorable Mahlangu is moving for the formal adoption of these minutes.
I'll second, Chairperson.
Honorable Okamp is seconding the adoption of the minutes. I take it that the minutes now are formally adopted as a true reflection of the meeting of the 18th of April, and therefore those minutes are now formally adopted. We now look at the minutes of the 2nd of May 2023. The minutes as well were shared with the members, so we are all aware. Let's just do the same exercise of quality assurance, looking if there are mistakes grammatically or in the content entailed. Scroll down. Members will raise their hands if there is any matter. Actually, this was quite a very concise and precise meeting of the day. Is there any mover for the adoption of the minutes of the 2nd?
I move Chairperson, Honorable Mama Rekhane.
Honorable Mama Rekhane is moving for the adoption of the minutes of the 2nd of May. Do we have a seconder?
Du seconds, Chair.
Honorable Du Toit is seconding the adoption of the minutes. That brings us to the formal adoption of those minutes as a true reflection of the meeting of the 2nd of May. We now move to the minutes of Tuesday, 16 May 2023. These minutes were also shared with the members. Can you scroll down? There they are, members. Is there a mover for the adoption of the minutes?
Before that, Chairperson, can I please request Nkululeko to flag the first page, which is the attendance?
Can you go to the credentials, the page with the credentials? You wanted to check if I am there or not?
Me, Chair. Okay, thank you.
Do you?
I can move, Chair, for the adoption of the minutes as a true
Honorable Tigele Mahlangu is moving for the adoption of the minutes of the 16th of May. Do we have a seconder?
I'll second, Chairperson. Okamp.
Honorable Okamp seconds. That then brings us to the formal adoption of those minutes as the true reflection of the minutes of the 16th. Let's now get into the minutes of the 30th of May. There they are, honorable members. Can we have a mover?
I move Chairperson Mama Rekhane.
Mama Rekhane is moving for the adoption of the minutes. Do we have a seconder?
Okamp will second.
Honorable Ocamp has landed with seconding, and that means the minutes have been duly adopted. Honorable members, that brings us to the end of our meeting. Let me express my sincere thanks for your attendance and for always showing commitment to play your role as public representatives. And this meeting has been quite fruitful, short as it may be. We've done a lot today. We've considered that presentation, dealt with the responses, adopted 4 sets of minutes. Thank you very much, honorable members. I wish you a good day. We will see you on the plenary. Thank you very much.
Thank you, Chairperson. Maybe we should take a copy of the amount of time that we spend and send it to the Honorable Karim.